Welcome, everyone. Thank you for joining us for the webcast Navigating Paid Sick Leave Laws, sponsored by EPAY. Before we begin, I would like to remind you that this webcast has been pre-approved for IHR certification credits 1 HRCI and SHRM recertification credit and e-learning credit. Please be sure to attend the complete webcast to receive your credits. You will receive an email from HR.com within 1 to 2 business days, which will include the certification credit information. Questions may be submitted any time during the webcast by typing the question in the Ask a Question text field and clicking Submit, the orange button located on your screen. And I will now turn it over to today's presenter, Michelle Lanter-Smith.
Thanks, Kathy. Hello, everyone. Again, my name is Michelle Lanter-Smith, and I'm from EPAY Systems. I'd like to welcome all of you to our session today, Navigating Paid Sick Leave Laws. Today I have with me Tracy Billows, and we are just really thrilled to have her with us. Welcome, Tracy.
Thank you.
Tracy is a partner in the Chicago office of Seyfarth Shaw. Seyfarth is a partner of EPAY's. We've worked together in the last 3 years presenting a compliance series and talking about issues such as the one today on sick leave, Department of Labor laws, and Affordable Care Act, and so on and so on. So we're thrilled to have this partnership with Seyfarth Shaw. They have provided our clients with much needed information. So again, thank you to your firm, Tracy, for again being with us today. I'd like to tell the folks on the line a little bit about Tracy. Tracy at Seyfarth provides extensive advice and counseling to clients on a wide array of human resource topics and issues, including policy development and review, auditing the HR functions, leave and absence management, EEO compliance, reductions in forces, employee relations, and the list goes on and on. She really brings a unique perspective to her clients. Prior to her legal career, she was a human resource executive in the corporate community. Wow, you don't see that very often. So great skills and talent being brought forward here with firsthand knowledge of, the challenges that clients face. Tracy is able to advise them in areas of labor and employment law, including employment policies and employee handbooks, training programs, sick leave, and many other issues. So again, thank you, Tracy, for joining us. If I may just take a minute here quickly to go through our agenda for today, I'm going to just spend about 1 minute to giving you a brief overview of EPAY, and then we're going to turn it right over to Tracy, because I know everyone's on the line to hear Tracy speak about what's out there today on paid sick leaves and what she might think is coming. So she's going to overview paid sick leave laws out there and select some of the paid sick leave laws that are in different cities around our nation, talk about some things you need to think about, and then the outlook going forward. So just a little bit about EPAY. EPAY has been in the human capital management technology space since 2001. We're headquartered here in Chicago, Illinois, and we've always been about developing SaaS-based solutions and services for companies that have employees spread across a lot of locations. We call that a distributed workforce. However, it happens in most hourly workforces. So that's really what we focus on, is enterprises that have large hourly workforces, where you really start to get some complicated issues in tracking people, paying people, and staying in compliance. This type of workforce can be very hard to keep up with laws, such as the one we're talking today. Can be hard to track, stay in touch with Department of Labor laws and things like that. But this type of enterprise, this is what we know and the companies we love to serve. Since our inception, our priorities have always been focused on providing software that's smarter and easy for these type of folks to use, because we do know that you don't have a lot of usually resource to handle that. So that's why some of the largest firms that you've seen that are in the business service industry that are up here on your screen right here, we are proud to call as clients today. So what makes us different in providing a full human capital management solution? And we do provide a full solution all the way from applicant tracking through HR, onboarding, payroll, time and attendance, and performance management. Is that at the heart of our solution, we have a very strong hourly workforce management time and attendance solution that really allows our clients to get at the heart of controlling costs and being in compliant. And then, of course, we provide many changes across the whole platform, from onboarding to paying people and getting their taxes done right, and being able to track things like sick leave, things that you need to be able to track, and a lot of the issues that Tracy's going to talk about today. We offer our customers 24/7, 365 days of support, which is really premium support for all of our clients. Every single client gets it. And it's what really clients say they love about us. And because of that, we boast a 99% customer retention rate. So that's a little bit about EPAY. But I'd like to turn it over to Tracy now. And again, everyone, please enjoy the presentation. Tracy?
Thank you. Thank you very much, everyone, for having me. I'm thrilled to be presenting with all of you today. It's great to be here. Unfortunately, I know the subject is not a favorite, in the sense that while everybody wants to hear about this subject, I think we all wish some of these paid sick leave issues would go away. Before I get in to the presentation itself, just wanted to go through my brief disclaimer here. The content of this presentation should not be construed as legal advice or a legal opinion on any specific facts or circumstances. These materials are intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. So I want to start by giving you an overview of the paid sick leave laws that are out there. And it is quite the overview, as I'm sure all of you know who have been keeping up with the trends with respect to paid sick leave. You know, current compliance with paid sick leave ordinances, and this is everything from municipalities, counties, states, and of course the executive order, which we will talk about. You know, compliance has always been complex, and every day it seems to get more and more complex. Just briefly, at the federal level, we have the Executive Order 13706. This provides paid sick leave for employees of certain federal contractors. We'll talk a little bit more about that executive order down the road here as we proceed through the webinar. But understand, it is currently the only federal mandate with respect to paid sick leave out there. There are 5 states right now that on a state level provide paid sick leave requirements for employers within their states. That would be California, Massachusetts, Connecticut, Oregon, and Vermont. From a municipality standpoint, I already have one to add to this. Since we've submitted these slides, we have one more ordinance that came out last week. So we're actually at 32 municipalities as of today. Cook County here in Illinois passed a paid sick leave ordinance last week. So that's 32 different municipalities that are out there that are implicating employers in this area. The oldest one being San Francisco. San Francisco and Seattle are 2 of the older municipalities in terms of having their laws in place. They have been around since before 2014, but we've just seen a tremendous surge in possible paid sick leave legislation, as well as past paid sick leave laws going into effect. With respect to also just briefly on the federal front, I'd be remiss if I didn't point out that, you know, for a number of years now, in Congress at the federal level, the Healthy Families Act has been introduced. It is a federal law that would require employees of employers with at least 15 employees to accrue paid sick leave up to 56 hours per calendar year. The bill that was promulgated never made it past committee, and it has been reintroduced on multiple occasions, but to date still has not been passed at the federal level, which is why I say the executive order is the only thing in existence at this point in time. But it is something that employers should be aware of. So, given the myriad of ways that state and local laws differ, employers need to look to establish policies and procedures that are sufficiently broad to ensure maximum legal compliance. So the first question when assessing paid sick leave issues is which employers are covered. And unfortunately, which employers are covered varies from law to law. Some laws talk about the number of employees in the employer's entire workforce. Some laws talk about the number of employees in the employer's workforce in that particular jurisdiction. And you can see we have some examples up here for you. The next question when assessing paid sick leave issues is ultimately employee eligibility under these laws in terms of their receipt of and their rights to paid sick leave. Oftentimes it's based on a certain number of hours worked in a certain time period. And you can see here, for example, it's 80 hours per year in New York City. It's 30 days per year in the state of California, et cetera, et cetera. Again, there is no consistent approach in determining which employees are covered. I also want to point out that in many cases, the employee coverage is far broader than existing policies. And here's what I mean by that. Many of these laws require all employees be covered under a paid sick leave policy. That means full-time, part-time, seasonal employees, interns, temps that you put on your payroll, not temps from other agencies. Although beware, some of these laws do talk about joint employment situations with contractors and with temporary and staffing agencies. The third question when assessing paid sick leave issues that needs to be addressed by employers are the paid sick leave accrual caps. And again, there is no one size fits all here. They vary by jurisdiction and jurisdiction. Generally speaking, there's a certain amount per year, meaning an annual cap. That is most common. Some of the laws, though, have what's called a certain amount at any given point in time, and these laws are what's called point-in-time accrual caps. Both annual and point-in-time accrual caps can also appear in some of these laws. Minneapolis is a prime example. They're one of the newer paid sick leave laws that are out there. And in Minneapolis, you have both an annual cap and a point-in-time accrual cap. The other issue that comes into play with respect to this accrual is whether you're using days versus hours. Certain laws define the amount of paid sick leave to be provided in days, whereas others define it in hours. This can make a difference for employees who work more or less than 8 hours per day in terms of calculating what overall paid sick leave they would be entitled to. Another issue that comes up with respect to these paid sick leave laws is, of course, the accrual rate. Generally speaking, most are 1 hour of paid sick leave is accrued for every 30 hours worked. Some are 1 for every 40 hours worked. And again, though, there is some variations here with respect to accrual rates. Additionally, there are variations in the laws with respect to the employer's ability to limit annual use. And what I mean by that is, believe it or not, many of these laws have one annual accrual cap, but also have a different annual usage cap, and they're not the same. So for example, in some of these jurisdictions, an employee can accrue up to 48 hours of paid sick leave, but an employer can limit their ability to use 48 hours of paid sick leave to only 24 hours in the given year. Now think about that. First of all, that makes for an administrative and compliance nightmare, but it also makes for an employer relations nightmare. How do we explain to employees that they've accrued 48 hours of paid sick leave, but technically under the law, we only have to allow them to use 24 hours in a given year? Hence, what happens is oftentimes employers, when they are tackling these issues, tend to be more generous in terms of an employee's ability to use their paid sick leave in a given year. Additionally, all of these laws have very different carryover requirements. Some specifically say if you front load paid sick leave at the beginning of your calendar year, fiscal year, whatever year you are using, you do not have to allow for the carryover sick leave at the end of the year. However, under the executive order, as well as under various municipal paid sick leave laws, including Los Angeles and Tacoma, Washington, you do not get out of the carryover requirement simply by front loading. And so again, you can see the laws are all over the place with respect to these requirements. Some other ways that the laws vary greatly. The usage waiting period. As you can see here, it varies from law to law how long newly hired and or existing employees have to wait before they can start using their paid sick leave. In California, it's 90 days after hire. In New York City, it's 120 days after hire. Seattle, 180 days after hire, and the list goes on and on. Additionally, another question when assessing, paid sick leave issues, and I'm really getting more into some of the technical requirements now, are the minimum increments of use. And what do I mean by that? Well, in many paid time off and vacation policies now, we dictate that an employee cannot use vacation, sick, or PTO in increments less than an hour. And oftentimes for exempt employees, it's 4 hours or 8 hours. Well, many of these paid sick leave laws have very specific increment usage requirements, meaning in Seattle, you have to let employees use paid sick leave under its law in 15-minute increments. In Connecticut, it's 1 hour increments. In California, it's 2 hour increments. Some of the laws make it even more complicated because what they say is it has to be the smaller of an hourly increment or the smallest increment your payroll system currently tracks absences or use of other time off. And think about that. That could require you to do extensive research to figure out what your current payroll systems are programmed to do, what your existing policies do, determine the most generous standard that you have in use, and ultimately provide that under your paid sick leave policy. Another area where the laws somewhat differ, but we do tend to see a little bit more consistency, is covered family members or covered uses of paid sick leave. Generally speaking, most of these laws allow people to take off time for not only their own illness or injury, but also for that of a family member. Family members are typically including child, parent, spouse, domestic parent, or partner, sometimes it's grandparents and grandchildren. Sometimes it's siblings. As you can see here in Seattle, it's household members. In Los Angeles and Chicago, it's somebody you have a close association with. So the list does go on and on. With respect to what notice you can require from your employees when they want to use paid sick leave, again, there is differentiation amongst the different laws as to what an employer can and cannot require. For example, if something is foreseeable, in some cases you can require up to 7 days. In other cases, you can only require up to 10 days. Generally speaking, for most jurisdictions, if something's unforeseeable, you can only say that they have to provide you notice as soon as practicable. Additionally, there is the question under these laws as to what documentation can be required. If you normally have a policy that says if somebody is absent for 3 or more days, that they have to provide you a doctor's note. Or if somebody is gone for a particular reason, they have to provide documentation. You need to check those policies against your applicable paid sick leave laws and jurisdictions to ensure you're not running afoul of those laws. As you can see, New York City, Oregon, Los Angeles, and Chicago, you can require reasonable documentation when somebody takes more than 3 consecutive work days. In Connecticut, Washington, D.C., and Oakland, California, it's 3 or more consecutive days. In Massachusetts, there are 5 different situations, generally including 24 consecutive scheduled hours of work. But you can see where this can get very complicated for employers, not only with respect to their paid sick leave policies, but their attendance and time tracking policies as well. Last but not least, each of these laws also have various record-keeping requirements, and the time frame for doing so can vary from law to law. So I highly recommend you review your document retention policies to ensure that they have been properly adjusted for any paid sick leave law requirements on a going forward basis. So I'm going to go through some of the paid sick leave laws, some of the more recent ones. That's the only way I could pick it, because I could be here for the next 8 hours talking to you about all the different paid sick leave laws out there. But I'm going to provide you a summary of some of the newer ones. Los Angeles. Los Angeles had a law in effect a couple years ago that only applied to hotel employees. And then effective July 1, 2016, it passed a law that says if an employer has 25 or more employees in the city of Los Angeles, it has to start complying with the paid sick leave law ordinance. And for employers that have 25 or less employees in the city, you have to start as of July 1, 2017. You can see here, and I'm not going to go through every single one of these details here, but it does apply to people who provide 30 days of work within a year. It is an accrual rate of 1 hour of paid sick leave for every 30 hours worked. And the accrual cap in Los Angeles is 72 hours at any given point in time. So this is an example. Remember, I talked about annual accrual caps versus point in time accrual caps. This is an example of a point in time accrual cap. And what it means is, because employees are allowed to carry over paid sick leave from prior years in Los Angeles going forward, the cap for paid sick leave is that an employee can have no more than 72 hours at any given point in time. Having said that, though, because it is a point in time cap, not an annual accrual cap, it is possible that an employee could take more than 72 hours of paid sick leave in a given year for you to be in compliance with the Los Angeles sick leave ordinance. Some additional requirements under the Los Angeles sick leave ordinance. As you can see here, it can be used for the employee's own health care needs, covered family members' health care needs, as well as to seek any type of aid or assistance related to domestic violence, sexual assault, or stalking. Now, if you remember when I was giving the general overview of paid sick leave laws, I talked about these annual usage limits. And here's a prime example where the annual usage limit does not meet the 72-hour point in time requirement. If you decide to just give employees that 72 hours point in time paid sick leave and not institute an annual usage, as you heard me say, they can easily take more than 72 hours in a given year. If you don't want that to happen, then what you have to do as part of your policy is institute this annual usage limit of 48 hours of paid sick leave. As I said a few moments ago, though, this does create an employee relations nightmare, because an employee understands that they have 72 hours of paid sick leave that they've accrued, but you're only letting them use 48 hours of paid sick leave. These laws, create these conflicts for employers in managing these issues, which results oftentimes in many employers simply doing away with the annual usage limit, but not all. The usage waiting period in LA is going to be the 90th day of employment. Notice requirements. The employer has to provide paid sick leave upon oral or written request of an employee. This is a big one. This means that you cannot deny someone paid sick time simply because they made the request orally. And many laws do have these different types of provisions with respect to the notice that must be provided. And with respect to documentation, you can, as an employer, you can require documentation to substantiate the need for leave only after the employee has used more than 3 consecutive days of paid sick leave. You also have to put up a posting in Los Angeles. Record retention is a period of 4 years. There's also issues with respect to, how are you going to pay employees? You have employees who have set salaries. You have employees that may be paid on commission that are eligible for this. So here's one example of how the laws handle it. With respect to Los Angeles, an employer has to pay an employee a wage of no less than the hourly rate set under the ordinance, which is basically the minimum wage. However, the wages do mean all amounts that the employee would get for the labor performed, including whether it's fixed or ascertained as of a point in time, or if it is done on a task, piece, or commission basis. Now I want to talk about the Chicago Paid Sick Leave Ordinance. This one is not going into effect until July 1, 2017, but it is getting a lot of press and a lot of questions because it has some unique requirements that we haven't seen in other paid sick leave laws to date. First, just briefly, what we have to show is that an employee has worked 80 hours in any 120-day period, and in any particular 2-week period performs at least 2 hours of work for the employer within the city of Chicago. Very complicated. 1 hour of paid sick leave is accrued for every 40 hours worked. The start of the accrual has to be either at the start of the employee's employment or on a particular effective date, whichever is later. The accrual cap is 40 hours per 12-month period. The carryover gets really tricky, though, under the Chicago ordinance. With respect to the carryover, first, generally, employees will be allowed to carry over up to a maximum of 20 hours. However, if your employee in Chicago also happens to be FMLA eligible and the employer is subject to FMLA in the city of Chicago, then you have to provide them an additional 40 hours, you have to allow them to carry over up to 40 additional hours of their paid sick leave that you can also require be used exclusively for FMLA eligible purposes. Think about what I just said there. You now have a paid sick leave bank that you have to split into two for tracking purposes. Either let them use all of the paid sick leave for all reasons, or if you don't want to be overly generous, you have to track paid sick leave that's been carried over pursuant to this FMLA exception, as well as paid sick leave that's been carried over just generally, and then determine when an employee is using paid sick leave for which reason. Additionally, there are particular other requirements under the Chicago Sick Leave Ordinance that require strict compliance. Certainly the reasons for use. Again, no surprises, it's for the employee's own illness or injury and receiving medical treatment, diagnosis, and care. It's also for a covered family member. You can also take time off for certain absences related to domestic violence, sexual offenses as defined in the Illinois Criminal Code. Also, though, here's one that is slightly different than some of the other paid sick leave laws. If there is a closure of the employee's business or the employee's child's school or place of business due to some sort of public health emergency, employees have to be allowed to use their paid sick leave to cover said time off. Again, you've got your annual usage limits here with respect to the Chicago paid sick leave, 40 hours per 12-month period, except, don't forget about that FMLA exception, they would be entitled to use an additional 20 hours for those FMLA qualifying reasons. The waiting period for new employees here in Chicago would be 180 calendar days. And with respect to notice, again, here differences among some of the laws. For foreseeable absences, an employer can require up to 7 days of notice before the leave is taken. And for unforeseeable, the employer may require notice as soon as practical. In terms of documentation, where a covered employee is absent more than 3 consecutive work days, then of course we can require a certification that the use of the paid sick leave was authorized. But again, this is more than 3 consecutive work days. A couple other technical requirements. There's a posting that will have to go up with respect to the Chicago City Paid Sick Leave Ordinance, and employers will be required to provide with the first paycheck a notice advising the employee of his or her rights under the Chicago Paid Sick Leave Law and all of the rights to take paid sick leave. With respect to how paid sick leave is paid under the Chicago ordinance, paid sick leave is time that is compensated at the same rate and with the same benefits, including health care benefits, that the covered employee regularly earns during hours worked. So let me talk briefly about Minneapolis as our next example. With respect to Minneapolis, I should note that a lawsuit has actually been filed to challenge the implementation of the Minneapolis paid sick leave law, so do pay attention to what happens with that lawsuit. We've seen other lawsuits come into play and have barred certain paid sick leave laws. Pittsburgh, Pennsylvania is an example of that. Pittsburgh and Philadelphia both passed paid sick leave laws. Philadelphia has moved forward, but there was a lawsuit filed to challenge the Pittsburgh paid sick leave law. For whatever reason, that one did work, and the paid sick leave law in Pittsburgh has not been implemented. So what we're seeing is a similar type lawsuit being filed related to the Minneapolis paid sick leave law, and we'll stay tuned to see what ultimately happens there. Assuming the lawsuit is not successful in stopping the law from moving forward, it will become effective July 1, 2017. It will cover any individual employed by an employer. Yes, I did say any individual employed by an employer. That includes full-time, part-time, and temporary employees who work in Minneapolis for at least 80 hours in a given year. Individuals will accrue 1 hour of sick time for every 30 hours worked in the city. And in terms of the start of the accrual, it will start as of their employment or the effective date of the law, whichever is later. In terms of any type of caps, if an individual has 6 or more employees, then of course we have to provide paid sick time. If it is less than 6 employees, we have to provide unpaid sick time. The total annual cap is 48 hours in a calendar or fiscal year, and then there's a point in time cap of 80 hours. Employers have to permit an employee to carry over accrued but unused sick time into the following year. Reasons for use under the Minneapolis paid sick time ordinance, again, some similar things, but a few other changes. Again, employee and family members, illness or injury, domestic abuse, sexual assault, and stalking absences, closure of the employee's place of business or family member's school for public health emergency. But here's another one: closure of the family member's school or place due to inclement weather, loss of power, loss of heating, loss of water, or any other unexpected closure. So think about those snow days that schools have. In Minneapolis, assuming the law goes forward, employees could request paid sick leave for their child's school being closed on a given day. It does appear at this point in time, we're waiting for further guidance from the city of Minneapolis, but it does appear at this point in time that employers cannot set an annual cap on the amount of paid sick time employees can use. The waiting period is 90 days following commencement of employment. In terms of notice, comparable to Chicago, you've got the 7 days advance notice when it's foreseeable, and you've got the as soon as practical if unforeseeable. In terms of documentation, an employer can require reasonable documentation that the employee used paid sick time for a permitted purpose only when the employee is absent more than 3 consecutive days as well. Some other quick technical requirements of the Minneapolis law. Upon the employee's request, an employer must provide the employee with information containing the employee's then current amount of accrued and unused paid sick time. And employers may choose a reasonable system for providing this notification. What that means is whether you do it electronically, whether you do that manually, etc. Also, you have to post a model notice. And if you have an employee handbook, you have to include a policy in the handbook that includes both the employee's paid sick time rights and remedies. In terms of record retention, here it's a 3-year period of time. And again, with respect to payment of paid sick leave, it's at the same hourly rate with the same benefits. So let me talk briefly now about the executive order. The final rule on the executive order governing paid sick leave for certain contractors came out at the end of September leading into October. The effective date for compliance for federal contractors and subcontractors is January 1, 2017. Employees who are eligible, any individual who performs work on or in connection with a covered federal contract. I'm not going to get into all the technical requirements. There's pretty complex definitions as to what a covered federal contract is, and I strongly recommend you partner with your outside counsel or inside counsel to determine whether you are covered, I will give you, generally speaking, that it's providing services to the federal government, not goods. Those that provide services to the federal government may find themselves with a covered contract, and generally speaking, those that only provide goods are not going to find themselves covered by this executive order. But again, there are a number of complicated pieces to the definition of a covered contract. Please, please, please make sure that you consult your counsel regarding your coverage. The accrual rate is 1 hour of paid sick leave for every 30 hours worked in connection with a covered contract. The accrual cap is up to 56 hours in a year. There is a year-end carryover of up to 56 hours, regardless of whether you use an accrual or a front-loading system. So here's an example when I was going through the sort of overall approaches to paid sick leave, front-loading versus accrual, and how some laws allow you to get out of the annual carryover requirements if you do front-loading. The executive order does not let you get out of the annual carryover requirements if you use a front-loading system. Reasons for use in terms of the executive order: individuals can use sick leave for themselves, for their children, their parents, their spouse, or any other individual whose association with the employee is the equivalent of a family relationship. As you can see, very, very broad, and there are no annual usage limits in terms of time off. So that is just a brief overview of just some of the most recent developments in paid sick leave laws. Now I want to get to some of the practical considerations that employers are struggling with as they're looking to try and figure out how to grapple with these paid sick leave issues. You know, because there are so many different laws to comply with and so many different provisions, you know, many employers are looking at a few things. One, they're looking at an accrual versus a front-loading system. You know, in general, you can have policies that provide paid sick leave, you know, to part-time employees through an accrual system, but a front-loading system to full-time employees if you want to do so. There's no requirement that all employees be provided paid sick leave in the same format, so much as they just be provided the paid sick leave they're ultimately entitled to under the law. You know, the pros to front-loading is you don't have to worry about accrual calculations or year-end carryover where the laws allow you to get rid of that. It's much less administratively burdensome for tracking. The cons of the front-loading system, though, is it can provide a windfall to part-time and temporary employees. Most of these employees may not even work long enough to get to accrue as much paid sick leave as they would get from a grant. But again, there you can talk about having two different systems for part-time versus temporary. You know, the accrual system, you don't have that windfall to employees at the beginning of the year, but you do have a greater administrative burden in terms of the accrual tracking, year-end carryover, and knowing that the accrual system can be different from jurisdiction to jurisdiction. The other issue is, you know, do we have PTO, vacation, paid leave policies, or some, you know, sort of other way to address this sort of paid sick leave issues? As I mentioned, you know, using existing vacation and PTO policies are possible, but it's complicated. You'd have to revise the policies to make sure that they meet all of the requirements of the paid sick leave law. That includes not only the total time provided, but the accrual rate, the carryover requirements, the employees covered by it. Typically, part-time employees of a certain level are not covered by such policies. Temporary employees are often excluded. Such policies may not allow employees to start accruing right away or may not let them take time off right away under existing policies. And again, don't forget that many of these paid sick leave laws have posting requirements, they have notice requirements, they have increment usage requirements, and you cannot retaliate against or discriminate against somebody who uses PTO or vacation for any of these protected reasons. It can make it very difficult to track what employers are using their vacation and PTO for if you're not using a separate paid sick leave policy. Additionally, because of some of these anti-retaliation provisions, you could find yourself running afoul of some of the laws if you have somebody who's been inappropriately using vacation or PTO, but to your knowledge, hasn't implicated any sort of protection paid sick leave laws. The problem is, though, an employee could claim that that is what they're using the paid time off for, and you can find yourself running afoul of those anti-retaliation and discrimination provisions. Some have looked at sort of this one-size-fits-all, coming up with a one-size-fits-all sort of paid sick leave policy. This is not to say that it doesn't work, but remember that would mean that you need to adopt for your national paid sick leave policy the most generous law that applies to you. So, for example, Seattle has unlimited accrual. And so, if, for example, in Seattle, people just would continue to accrue paid sick time without any particular cap. So if you wanted to use Seattle as your paid sick leave model, you'd have to keep that in mind. With respect to, carryover issues and such, again, you'd have to find the most generous provision. Additionally, with respect to increment usage, depending on the jurisdiction you're in, that could mean the smallest increment you use, that could mean 4 hours, that could mean 2 hours, that could mean 1 hour. And I can go on and on and on about the different ways that you would need to factor in all of the myriad of different paid sick leave laws that are out there to determine which is the most generous in terms of your compliance with the one-size-fits-all. Last but not least, there's this notion of unlimited PTO that many employers are considering. And unlimited PTO can raise a whole host of risks and concerns as well. First, employees' short-term, non-extended absences for reasons covered, under applicable paid sick leave laws. Arguably, any time somebody took off then on an unlimited basis would have to be protected, as opposed to saying we provide absences up to the annual caps, for example, that these laws allow for. So certainly, that is an issue with respect to these unlimited PTO policies. Additionally, even though I have, unlimited PTO on here as an option, we really strongly encourage you not to use the term unlimited when describing this policy, because that really does suggest that it is unlimited, meaning I could take 12 weeks, 16 weeks, 20 weeks, etc. So certainly what we recommend in terms of crafting these policies is coming up with sort of like a routine time off policy and carving out certain leaves and time off for things like FMLA, STD, etc. But again, there's risks in doing that as well. And then last but not least, record-keeping risks exist with these sort of quote-unquote unlimited PTO policies. Most laws require employers to maintain certain records of an employee's accrual and use of paid sick leave, and this certainly can conflict with this sort of notion of unlimited PTO where you're not tracking information. All right. So with that happy news for what we've seen thus far, what are we seeing on the horizon for the remainder of 2016? Effective October 1, Montgomery County, Maryland had its paid sick leave law go into effect. January 1, 2017, Vermont will be the next state law to go into effect. Santa Monica, California has a paid sick leave law going into effect on 1/1/2017. Spokane, Washington has its paid sick leave law going into effect on 1/1/2017. And federal contractors has its executive order with respect to paid sick leave for covered contracts going into effect on 1/1/2017. If I could pull out my crystal ball and sort of start guessing as to what next locations are likely to adopt paid sick leave ordinances, well, I've already correct about one. Under municipalities, Cook County, as you can see, can come out of the likely to adopt and move into the actually adopted paid sick leave ordinance. But additionally, from a statewide perspective, where we expect to see some potential movement is the state of Washington. That's in large part because there are a number of municipalities in Washington, including Tacoma, Spokane, Seattle, etc., that already have paid sick leave ordinances that would make it very likely that the state would move in that direction. Maryland, New Jersey. New Jersey is like the state of Washington. It has over 9 municipalities right now that have paid sick leave laws, and Michigan. In terms of municipalities, Albuquerque, New Mexico is on the horizon, Duluth, Minnesota, and Duluth is probably a likely one considering both St. Paul and Minneapolis have already passed their own paid sick leave ordinances. And then Princeton, New Jersey is the next one in New Jersey to hit. So now I am going to turn it over to questions. I know we wanted to leave 15 minutes. I think I've only left 10. My apologies. But I'm going to look at some questions here that have come in. Let's see here. Try and expand these questions so I can read it. Are there special circumstances for part-time employees with respect to paid sick leave compliance? Unfortunately, under most of these laws, with respect to paid sick leave compliance, part-time employees are not treated any different in terms of their rights. So for example, you can't prorate an employee's paid sick leave entitlement. If the law provides, for example, 80 hours of paid sick leave, and you have an employee who only works a 50% schedule, you cannot prorate for a part-time employee and say they're only going to get 40 hours of paid sick leave. If you front load paid sick leave to employees, you have to front load to part-time employees the same amount you would front load to full-time employees. And if you accrue paid sick leave for your paid sick leave policy, then they have to accrue at the same rate as everyone else. Now, having said that, they may not ultimately accrue the full amount allowed under by the law, depending on their hours worked, but you can't make any adjustments for their part-time status. Additionally, part-time employees are subject to the same protections with respect to paid sick leave, meaning their absences are protected. Additionally, with respect to part-time employees, they have to be given the same notice. So for example, if it's required that you put something on their paycheck, part-time employees get the same requirements. If you are required to give an employee written notice of their paid sick leave rights, that applies to part-time employees. And of course, anything else. So as you can see here, there really isn't a difference for part-time employees that can come into play. Are there some exceptions, for example, like under the Chicago law for collective bargaining employees? Yes, each law is different with respect to exceptions for collective bargaining agreements in union employees. For example, in Chicago, unless you have a contract that's expiring after the effective date, you have a window of time, a period of time where as long as your collective bargaining agreement paid sick leave at or above the rate of what the law requires, you don't have to make any adjustments to your paid sick leave policy until your next contract negotiation. However, if your current paid sick leave offered in Chicago is at a rate lower than what the law requires, then the CBA exception likely will not apply. Similarly, the executive order has a provision as well with respect to CBA exemptions and such that also comes into play. So what you have to do is look at the date of your collective bargaining agreement. You have to look at the level of paid sick leave that's provided, and you have to determine if you are presently meeting at least the time allotment for paid sick leave. And if you are, then the exemption may apply to you. But I highly, highly recommend you reach out to counsel to discuss that, because there are some technical requirements that have to be met in many of these cases. And you want to make sure you're meeting those to fully avail yourself of the CBA exemption that is out there. All right, so now I'm looking at some of these other questions that I have here. Bear with me a moment as I'm looking at this. Let's see here. Many of these sick leave ordinances become effective in July. Does the next year's hours start from the time the ordinance started or on a calendar year? Great question. So if the ordinance is starting as of July, as of that effective date for purposes of that year, you are looking at from July going forward. But what employers are struggling with is many employers don't want to change their paid time off policies to run from July 1 to June 30th. And so what they struggle with is, how do I develop an annual policy but also meet the implementation requirement of July 1? So some are looking back to January 1 just for purposes of eligibility, for purposes of use, et cetera, to make sure that they don't have to worry about making adjustments 6 months later because of the half-year implementation considerations related to the new paid sick leave law. Let's see here. Sorry, I'm scanning through some other. So with respect to Cook County, are there any other limitations other than being in Cook County? No, it's for employers who are in Cook County. So it doesn't matter what municipality, Chicago or otherwise. If you are in Cook County, you will be covered by the paid sick leave law, assuming you otherwise meet their requirements. There's been an asked clarification is to explain front loading versus the accrual rate. So front loading is where, I'll use California as an example because they're one of the first to adopt front loading. California says if you are going to front load employees' paid sick leave, you must do so at the beginning of the paid sick leave year that you're using, which most people are using calendar or fiscal years. And in California, if you use a front-loading model, and let's just assume for argument's sake for answering the question that you are using January 1 as the beginning of your year, you are front-loading paid sick leave at on January 1, the full 24 hours, which means the individual can use that 24 hours of paid sick leave starting on January 1 and at any point in the rest of that calendar year. If you're using an accrual system, what it means is starting January 1, employees are accruing paid sick leave for 1 hour for every 40 hours worked. And interestingly, in California, if you use the accrual system, employees can accrue up to 48 hours, so you cannot cap the accrual at the 24 hours. Their law is unique that way in the sense of how they are providing that. But nonetheless, that is the difference between front loading and accrual. It's basically giving the employee on that fixed day of, as I said, January 1, the fiscal year, or however you're using it, all of their paid sick leave to use up front for the remainder of the year. Let's see here. Does sick time have to be carved out of PTO time? Great question. So if you're using your PTO policy and to comply with a paid sick leave law's requirements, you have to look to see what notice requirements and tracking requirements you are required to meet under the law. If the law requires that you are going to be, giving an employee, for example, notice on their paycheck stub, which is required in California, or notice upon their request, which is what we saw in some of the more recent laws, then what that means is you do have to track in a PTO policy the reason somebody is taking time off. And that's very frustrating for employers because the whole reason for going to PTO in the first place was to not have to track the reasons for absences. And once that happened, once we, sort of transitioned all these PTO systems, most employers said, look, we don't care what your reason is for taking the time off. Take the time off, and as long as you're staying within your PTO limits, that's okay. However, the problem is with respect to these paid sick leave laws, you now have to pay attention to the reasons people are using their PTO if you are going to use a PTO policy to comply with these paid sick leave ordinances. That's why many employers, not all, but many, are looking at going back and moving away from PTO and going back to vacation and sick leave as separate policies. One of the questions is, will there be any discussion of any Canadian laws on this? At this point in time, no, we are solely focusing on U.S. laws today with respect to paid sick leave. But know that various countries outside the United States have very extensive paid sick leave laws that can come into play, and certainly that you should be aware of on a global basis. Is there one source that I can access that lists all current and future state, city, municipality, et cetera? I'm not aware of any free resource that's out there right now that tracks that. Many law firms, including my own, have subscription services that we offer to clients that allow them to help track the different paid sick leave laws that are out there. But I'm not aware of a single go-to one-stop source for this information that's provided to employers for free. Let's see here. Next one is, we are a federal contractor. So with respect to the municipalities and where people live in, it looks like how are we rectifying the federal contract in the different locations? So the federal contract is tricky because the federal contract issue is any time an employee is providing work on a covered contract, they are entitled to the paid sick leave benefits under the executive order. It doesn't matter where they work under the executive order, they're entitled to those benefits. Having said that, if you are in a jurisdiction that provides greater paid sick leave rights than the executive order makes clear that that state or municipal law will govern over the executive order. And what I mean by that is, so I'll use San Francisco as an example, where you can accrue up to 72 hours in a given year, but the executive order is 56. If you have somebody who is working on a covered federal contract or subcontract, but they're working in San Francisco, it's not enough to comply with the executive order. You also have to comply with the San Francisco requirements. Again, lots of complicated questions that employers are grappling with. I see I have 2 minutes left, and I know that there are some concluding remarks from EPAY, so I tried to get through as many questions as I could. But I thank you all so much for your time and for being with me today on this very complex subject.
Great. Thanks, Tracy. That was unbelievable, the amount of laws and the complexity. I'm sure, like us, everyone is very overwhelmed, but I think you actually helped clear up some things. So thank you very much. Very much appreciate it, your time.
You are welcome.
I would like to just wrap up in the last couple of minutes and just tell you a little bit about what you can receive with a full HCM platform from EPAY. If you could just go to the next slide, Tracy. We, again, as I had said, offer a full human capital management solution. And some of the features within that solution, obviously, are payroll with accrual systems and HR. Excuse me. And so the first thing you want is obviously a system that can provide seamless flow of information so that you, as you're onboarding employees and you move them through the whole process from into HR, time and attendance, and payroll, you only have to enter it once. You only have to set up things like we've talked about today once in the system. So when you're talking about benefits and vacation and sick time, you set that up once based on the policies you have, and it's tracked both in payroll and your benefits system and HR and so on. So that's the first point that I wanted to make, is that a seamless system is the way to go. The next is you got to look at your accrual systems. So we have accrual capabilities, being able to manage some of the things that Tracy talked about today at both the payroll level and also the time and attendance level. So it gives you a lot of flexibility of how you're going to track these things. You can, in our system, track accrual caps, the rate that accruals, or the rate that the sick leave and vacation leave is accrued, carryover limits, and more. So the tracking is very important. So we give you the flexibility that you can have multiple policies across the nation and be able to track all of them. And, you know, you don't necessarily have to do a one-size-fits-all policy like she was talking about, which isn't necessarily a good idea. You can have multiple policies going on by pay group, by state, so on. So that's some important things to know. You also want to know that when you're tracking different leave types, you can do that in the system. So if you have someone that is working or was supposed to work today, and in the time and attendance system you normally would have put in their 8 hours, but they took a sick leave, you can track that 8 hours as sick leave time and at the sick leave rate type. But you may also have a different rate type for perhaps paid leave, vacation leave, and so on. So we can track the various rate types. We can track the various different types of leave. Now, there's another piece of the system that this data and this information has to flow into, and that's your scheduling system. Because then when you're going to build schedules, if someone obviously can't necessarily, you might know if they're going to be out sick for a while, but if they're going to be taking vacation, right, you need to be able to track that so that you can build a schedule that's accurate. So we have that capability. And then finally, just to wrap it up, you have a self-service tool with our platform so that folks can go in and not only they can request their vacation, they can say that they've got sick leave or they need to take sick leave, but then it can also be approved and they can look at their balances. So they have an employee self-service tool to be able to easily go in and do that, to request it, to talk about what's happening to them. And then in addition, of course, on all of their pay stubs, they can see exactly what type of leave they have taken. So that's just a little of information of how EPAY can address some of the needs that were brought up from Tracy today. On the next slide, you'll see, again, a depiction of our full platform from applicant tracking all the way through the elements you need to track the employee through their whole life cycle and their stay with the company: human resource management, benefit admin, time and labor, payroll, and performance management. We have a SaaS-based solution that we wrap with administrative services so that you can offload some of the work and we can do it for you everywhere from payroll outsourcing, tax management, Affordable Care Act, and other ancillary services such as COBRA and some FMLA tracking. All right, I'd like to wrap up then. If you could go to the next couple of slides there, Tracy, and move forward. These are just some of our highlights. But the most thing I want to tell everyone about is on Thursday, we will be having a webinar at 10 a.m. Central Time that is October 20th. And it's a session we do on how to evaluate human capital management technology. Well, we'll talk about the important things of how you can evaluate it, and you actually get a sneak peek of our software. So if any of this has piqued your interest and you're interested in taking a look at EPAY, all you have to do is go to our website and go to upcoming webinars and sign up for Thursday's webinar. We would welcome your attendance, so thank you very much. At the end of the survey today, you will have a quick survey, and Kathy will tell you more about that. But on behalf of EPAY and Tracy, again, thank you very much. We appreciate your time this past hour. We hope you got a lot out of it. Thank you very much, and we look forward to talking to you soon.
Thank you.
Kathy?
Bye now.
Yes, thank you, Michelle and Tracy, for presenting this very informative webcast today. The archive webcast and slides will be available on the HR.com site within 24 hours. You will receive an email from HR.com with the certification credit information within 1 to 2 business days. EPAY and HR.com do appreciate your feedback, so please take a moment at the very end of the webcast to complete the evaluation survey, which will appear on your screen. This concludes our webcast, and thank you again for joining us, and enjoy the rest of your day.